My name is Bree, and I am the Welfare Rights Centre's Events and Communications Officer. Welcome to our Migrants and Centrelink webinar. I am joined this afternoon by our Senior Solicitor, Donna Flood. We at Welfare Rights Centre acknowledge the traditional owners of the land on which we are today, the Gadigal of the Eora Nation, and pay respects to elders past and present. We recognise that this land always was and always will be Aboriginal land. So you should have received a copy of the slides this morning if you registered for this session through our website. They are also available in the chat right now. A recording of this presentation will be edited and uploaded to our website later in the week, and you will receive an email notifying you of this when it has occurred. Please write any questions you have regarding the content into the chat box. We'll be stopping several times to answer your questions. We may not be able to answer all of the questions due to time constraints, and please keep your questions broad as we cannot give out any legal advice today. Questions regarding very specific situations cannot be answered. We'll be adding links to relevant information into the chat throughout the session, and there will be a 5-minute break about halfway through to allow you to stretch your legs. So introducing Welfare Rights Centre. Welfare Rights Centre is a community legal centre specialising in social security and family assistance law. We provide free legal information, advice, referrals, and representation to thousands of New South Wales residents each year that have a problem with Centrelink. Our peak organisations. Our peak organisations are Community Legal Centres New South Wales and Economic Justice Australia, who we work with to advocate for law reform. I will now hand it over to Donna.
Good afternoon, everyone. So the aim of today's session is to go through some of the basic structures of Centrelink payments when you're assisting someone who is a migrant or a newly arrived resident. We look at the fact that there isn't a single rule. There's no nice one single neat sort of process, package or rule for everything. I'm going to be going through the different exceptions that you might be able to get and look at to get one of your client on a payment when they may otherwise not be eligible. And we'll look at when it's appropriate to refer to us or your local community legal centre that assists with social security matters to get ongoing support. And hopefully you'll be able to help your clients as well with the information we've provided. One of the things that it's important to know is that although I am a lawyer, this is not legal advice. The information I'm giving you is information only. If you would like legal advice, please seek out the advice of a lawyer. This is merely for information. So we thought we'd start with a poll so that we can gauge, what kind of issues you're seeing, what the people attending this are facing and what Centrelink issues you're seeing.
I'm just launching the poll. You can answer with more than one if you have several issues that you're seeing. So there's understanding how the system works, understanding the rules for each payment, issues of residency, visa category, unable to lodge an application, newly arrived residents waiting period, proving substantial change in circumstances for special benefit, access to Centrelink payments through international agreements, locked out because a New Zealand citizen, assistance with appeals, and accessing interpreters when in offices, information in language, and difficulty accessing a social worker, which is always a popular one. So the biggest issues that people are seeing is understanding how the system works, issues of residency, visa category, unable to lodge an application, and understanding the rules for each payment. So hopefully we'll be able to help a little bit with that today.
We're going to start with general issues of eligibility for Centrelink payments rather than those issues that are specific for newly arrived residents. The thing to be aware of is that there are eligibility criteria for all Centrelink payments, and whether you're a new migrant or not, your clients might be facing issues with them. Most payments are going to need evidence of how the applicant has been supporting themselves in the previous period, in the previous months or days. It might be bank statements, it might be separation certificates. Most payments will also have an income and an asset test, and so they're going to need information and proof about the applicant's income, but it'll also need information about their partner's income. And whether the person applying thinks they're in a relationship or not, it's the way Centrelink look at relationships and the way Centrelink defines what a relationship is might be different to how they do. So it's really important to be aware and to be conscious that someone may be in a relationship, and their partner's income and assets are going to be important. And Centrelink is also going to need proof of ID. Now, for migrants and newly arrived residents, that can be an issue. And if they're unable to provide proof of ID, they can ask Centrelink for assistance. Centrelink does have alternate ways of proving ID and birth, and actually your Centrelink payment can be paid for 4 weeks, 2 fortnights, even if you don't have adequate ID. But you do only have those 4 weeks to get adequate ID and get it to Centrelink to prove your eligibility for a payment. Otherwise, your payment may be cancelled. So one of the things to be aware of as well is that the Department of Home Affairs does allocate an assumed date of birth when the date of birth of someone is unknown, and Centrelink is obliged to accept that information. So if that's a situation that your client's finding themselves in, that's also one of the things that's available. So when we're looking specifically at migrants and newly arrived residents, there are some very particular things that they face. Now, this is a very busy and possibly slightly overwhelming slide, and what we're going to be doing for the next hour or so is slowly going through this so that I hope that in the end, this particular image is going to help you when you're talking to your clients and you're working through their issues so that you can work out how to help them. So, when we're talking about things that are facing migrants and newly arrived residents, common eligibility criteria for most Centrelink payments are that the applicant needs to be a permanent resident visa holder or an Australian citizen. They need to have been physically located in Australia when the application is lodged, and they need to intend to remain in Australia and call Australia their home. So when you're talking about whether someone's a resident of Australia, it's not whether they're on whether they're on the appropriate visa, though they do have to be a permanent resident visa holder. For resident of Australia, it is that needing to intend and calling Australia home. And they look at those 5 different aspects when trying to make a decision about whether someone is calling Australia home. So when you're talking about whether you're on an eligible visa, it's that permanent versus temporary resident. Each visa number is classified as either permanent or temporary, and each visa number is specified as to whether they've got access to a Centrelink payment and what Centrelink payments they've got access to, as well as other criteria that they face. As a general rule, but there's always exceptions, most temporary visas have no eligibility and most permanent visas have eligibility, but there's always exceptions. So the first thing you should be doing is asking your client for their visa number and checking what their eligibility is. And there is a specific website. The link is there on the slide here, and it lists every single visa number. It lists whether it's a permanent visa or a temporary visa, and it says specifically what Centrelink payments they may have access to and what additional requirements there may be. So you can see in that final column whether it's got the hyperlinks to the individual payments that people are eligible for. It's got links to notes that give you extra information, and it also has other information that's useful. So Once you've gotten through whether they may be eligible through their visa and their residency status, every single payment that you're applying for also has its own unique eligibility criteria. You're looking at whether, to access some payments, you need to be looking for work, or to access other payments, you need to be caring for children. Other payments may need evidence that you're caring for someone else, or that you've got an illness or a disability. So there's all of those sorts of criteria that your clients are going to have to get through as well to access a payment. So migrants and newly arrived residents might have barriers to accessing payments that have got nothing to do with their immigration status. So when we're going back to that slide that we had earlier that has the different, the overview of getting access to a payment, the first question is, what visa are you on? Are you on an eligible visa? You're looking at a particular payment. Are you eligible for that particular payment because of the specific aspects of that particular payment and the specific requirements of that payment? And if the answer is yes, you move on to the next stage. If it is no, then you might be looking at needing to get some legal advice. Okay, so you're on the right visa. You're eligible for a payment due to, parenting responsibilities or other aspects. The next thing you've got to look at if there is a waiting period, because even if you satisfy all of those aspects, the visa and everything else, it might be that you're going to have to wait before you can actually access the payment. So one of the main waiting periods is what's called the newly arrived residents waiting period. Most Social Security and family assistance payments have one. The start of the waiting period is the day that you arrive in Australia on a permanent residency visa, or if you're granted an onshore permanent residency visa, the date that you are granted that visa. It's whatever is later, whatever is the later one, okay? Any time that you might have spent in Australia before the granting of that visa doesn't count. You might have been here for years before you get your permanent residency visa. That doesn't count towards the waiting period at all. If you leave Australia for any reason, because time outside of Australia doesn't count, so time on holiday or time returning to another home for any reason, doesn't count towards your waiting period, but it is cumulative. It all just adds up together over time until eventually you've gone through your waiting period. And the different payments have different waiting periods. So you need to be looking at the specific payment you're applying for to see how long your waiting period is. So most payments, as you can see, it's 4 years. Most of the main income support payments are 4 years. Carer payment, however, is 2 years. Family tax benefit A is only 1 year. And family tax benefit B and childcare subsidy, there is no waiting period. Your clients are eligible for that for the moment, from the day they get their permanent residency visa or the day they arrive in Australia. So if we're looking at, for a case study situation here, we've got Carl. Now, Carl arrived in Australia in March 2020, and he arrived on a permanent residency visa. So his waiting period started the moment he landed. February 2021, he travels back to Germany for a holiday, and he stays in Germany for a month before he arrives back in Australia in March 2021. Then in December 2021, his mother becomes ill. He returns to Germany to care for his mother, and he stays there for a year. When his mother dies, he comes back to Australia in December 2022. So you can see you've got 3 different separate periods where he has been in Australia on his waiting for the newly arrived residents waiting period. He has only completed 22 months of his newly arrived residents waiting period because he was outside of Australia for 13 months. And so he's extended that period of time that he's going to have to wait before he gets access to a Centrelink payment. Okay. One of the other main waiting periods that we come across is what's called for newly arrived residents and migrants is what's called the qualifying residence period. Now, this is actually a 10-year waiting period. It's for the age pension and the disability support pension. And this one, even if you're an Australian citizen, permanent resident, protected visa holder, it doesn't matter. You're still going to have a 10-year waiting period. Now, for the newly arrived residents waiting period, if you are an Australian citizen, then you no longer have to sit out that waiting period. For the qualifying residence period, you do need to wait. You do have to wait out that 10-year period. Okay, so that 10-year period doesn't have to be done in one lot, but unlike the newly arrived residents waiting period, 5 years of that 10 years must be done in a single block. The other 5 years can be in as small or larger blocks as you like, but 5 years must be in a single block. If you've got someone who's not able to access a payment, usually age pension, because of the qualifying residence period, they may be able to access the special benefit payment instead while they're waiting for their 10 years to end. It is important to remember, though, that special benefit has a 4-year waiting period. So they'll only be able to access special benefit for the final 6 years of that 10-year waiting period. Okay. So if we head back to this slide, we've now looked at whether someone's on an eligible visa. You've looked at whether they've got any of those, they've covered off all of those eligibility things for that particular unique payment. You've looked at whether there's a qualifying residence period for that payment, that 10-year waiting period, and whether they've been here for long enough. You've looked at whether there's a newly arrived residence waiting period, usually 4, sometimes 2, sometimes 1, and whether they've been here long enough. And then if they have been here long enough for all of those, you lodge an application. Okay. This is our first chance to have a stop for questions. Does anyone have any at this point?
There's one question here. It's regarding the case study.
Yeah.
I would like to know, does Carl not need to be in Australia for 2 years continuously?
No. So with the newly arrived residents waiting period, you don't need to be in Australia. You don't need to sit out that waiting period in any particular length of time. To be considered a resident of Australia, you need to be considering Australia as your home. And so one of the things that Centrelink will look at is whether they think that you intend to stay in Australia for 2 years. But that's when looking at that residency, that sort of, that decision about, are you in Australia? Is this your home? It's got nothing to do with the newly arrived residents waiting period at all. The newly arrived residents waiting period can be done in any chunks of time. There's no requirement that one chunk must be 2 years.
Okay, there's a few more questions now. Will they receive special benefits for the last 6 years until they get pensions?
So what you need to do, I'm not going to guarantee anything. What I am saying is that if you have a client who is of age pension age, who has applied for the age pension and has been told they're not qualified for it, they can't get it because of the qualifying residence period, then my recommendation would be to put in an application for special benefit, because special benefit is that payment that is available for only people where there is absolutely no other payment that they may be able to apply for and receive. And when you're of age pension age, there is no other payment that you would be able to get under the social security system.
What happens when there is domestic and family violence within the relationship?
So what we're going to be doing is we're going to be spending a lot of the remainder of this session on the exceptions to the rules preventing people from getting onto a payment. So we've talked about what's preventing someone from getting on. Now we're going to give you information about the exceptions to that and how you might be able to help your client to get onto a payment even when it appears they're not eligible.
Okay. Will you be covering New Zealand residents separately?
We're going to be talking very briefly about New Zealand residents. Really, we could do a 1-hour session on New Zealand on its own. And so this is just going to be briefly talking about it separately and closer to the end.
Okay. For the 5 years block within the 10 years qualifying period, can that person still travel and have holidays overseas?
I would have to look that up, I'm sorry.
Regarding parental leave, have you seen any successful appeals for less than 2 years of parental leave?
That one I would have to look up as well.
Is special benefit only paid once for 6-month periods for New Zealand participants who are not permanent residents?
No, that's not the new, that's a, no, that's not what special, that's a different thing. I will try and remember to cover that when I get to New Zealand citizens. Maybe, Bree, you'll be able to remind me if I forget near the end.
Okay, just making a note of that.
Thank you.
If taking from the case study, if Carl got permanent residency or citizenship, for him to get age benefit, does he have to live for 5 years straight within the 10 years?
So Carl has permanent residency. That's why he's able to sit out. That's why he's going through his newly arrived residence waiting period. If he was on a temporary visa, then his newly arrived residence waiting period wouldn't have commenced. Now that it has commenced, his newly arrived residence waiting period, there is no restriction or limit to, how long those periods of time in Australia are. But yes, if he was wanting to apply for the disability support pension or the age pension at some stage in the future, then he would need to have stayed in Australia for a 5-year continuous period within the 10-year waiting period that he has to wait to get access to those two payments.
And if he went on holiday for a few weeks, would that affect anything?
Unfortunately, that was a question that was already asked, and I would have to look that up. I'm sorry.
For those applicants that are awaiting a High Court decision on their 866 permanent residency visa, does the wait period apply to them too?
I don't know anything about specific visa numbers or about High Court decisions. I just know that your waiting period doesn't commence until you are granted a permanent residency visa.
Okay. Yeah, so if they're waiting for that to be granted, it doesn't commence until then. So I guess that would answer it. Okay. I'm sorry. The next question, it's too specific. We can't give out legal advice, just so you know. So sorry, we'll have to carry on with the webinar.
Okay. So exemptions for the newly arrived residents waiting period. So this is where you've got a client been told that they can't get a payment because they're on this newly arrived residents waiting period, and what questions you might need to ask or what you need to be looking for to see if maybe there's an exception and they can get access to a payment. So not everyone who arrives in Australia needs to wait out that waiting period. It can depend on what payment they're looking for and what visa number they're on. If they have ever been on a temporary humanitarian visa, if they are a refugee, a permanent humanitarian visa, if they've ever been a refugee, or if they're a family member of a refugee, or if they are an Australian citizen. So they might have received their citizenship during their newly arrived residence waiting period, then they can get access to a payment. There are also exemptions that are attached to events that might have happened after they've arrived in Australia. You might be able to get access to special benefit if you've experienced a substantial change in circumstance, or parenting payment if you became a lone parent while a permanent resident. You also can get one payment of crisis payment if you apply within 7 days of arrival in Australia, if you have arrived as a refugee. On one of those humanitarian visas, you get access to that single payment of crisis payment. So for the refugee exemption, if you are a refugee or a former refugee at the time of your application for a payment, if you are a family member of a refugee or family or former refugee, you're also exempt. However, the family member must be a partner of the refugee and must have been a partner at the time the person became a refugee. They must be a dependent child in full-time education who's under 22 years at the time they lodge their application. And they must have been a dependent child of the family member at the time the family member became a refugee. Or they must be another person who should be treated as though they are a dependent child for the purpose of this definition, even if they don't completely and totally fit that under 22 full-time education dependent child. If the refugee has died in the meantime, and before the application is lodged, the person applying must have been a family member immediately before their death. So refugees are people who have been granted a visa under the Department of Home Affairs humanitarian visa program. The grants are both onshore and offshore visa grants, and the visa subclasses are usually in the 200s. But thinking back to that earlier slide and the link that's on that earlier slide, don't rely on this visa club subclasses in 200s. Look at every single visa number of every one of your clients and double check it. It will say exemption from the newly arrived residents waiting period next to the visa number if there is an exemption. So we have a case study here for you.
Hi, Asha. My name's Daniel. I'm calling from Welfare Rights Centre for your appointment today. How are you going?
Hi, Daniel. I'm good. Thanks for the phone call.
You're welcome. So I've got a little bit of information about your circumstances. Would you mind just telling me in your own words what's happening with Centrelink?
Well, basically, I'm a bit frustrated because I applied for a payment from Centrelink, but they said I can't get anything from them, and I don't know what I'm going to do because it's very difficult for me to pay the rent and pay for the food as well. My dad only gets job seeker, and everyone in the family is just living off that for now.
Right, so it sounds really difficult. Can you just tell me about your interactions with Centrelink?
Sure. It's, again, very disappointing because they're the ones that told me to apply for something called the youth allowance.
Yeah.
Because I'm studying full-time at high school. I filled in all the forms. I gave them the documentation that I had. And then I got a letter 2 days ago saying that I'm not entitled to the payment because I haven't been in Australia long enough.
Yeah. Okay. That's called a newly arrived residents waiting period. And I'll talk to you a little bit about that in a moment, but I just want to get some basic information first. So can you tell me, first of all, how old are you?
I'm 21 right now.
Okay. And you've received a letter from Centrelink, correct?
That's correct. I got a letter, a physical letter. I also got an update on my MyGov portal. Okay.
And do you have that letter with you?
Yes, I do.
Okay. Can you just read the section explaining why your claim was rejected?
Yeah, sure. I'll just bring that up. Now, it says here that I have to wait 4 years from the date I was granted permanent residency because of the newly arrived residence waiting period. Yeah. That's something that you mentioned as well, but I don't know what it is exactly. Sure. So I'm not eligible for this until 27 July 2025.
Okay. All right. That may be correct, but there may also be an exemption you can apply for. So I just want to talk to you about before you came to Australia and why you came to Australia. Can you just tell me about that?
Yeah, so my father was the first one in the family who came to Australia in 2014.
Yeah.
Since then, my mother, my elder brother, and I have been trying to come to Australia for about 7 years.
Mm-hmm.
So it's taken 7 years to get our visas. When we finally got here, everything was really perfect. We liked it. But going forward from that time, it was difficult for my father to support 4 people in the family just on the job seeker payment. And it's been quite stressful for all of us.
Yeah, I bet. And you mentioned that your father came here earlier. Do you know what visa he arrived in Australia on?
So he came as a refugee and he was on a protection visa.
Yeah. Okay. All right. Well, I'm just going to look into the visa issue a little bit more, but I think based on what you've told me, we might be able to help you.
So thinking back on Ash's story, we can see that he's 21 years old and in full-time education. So he's under that 22-year limit in the definition. We've been told that his father arrived in 2014 as a refugee. He's got an older brother and a mother. And so when we're looking at that, we can say specifically that Asher can appeal the rejection of his youth allowance payment based on the fact that he is a dependent child of a refugee. So that newly arrived residence waiting period should not apply. And in this particular situation, he was granted youth allowance and it was backdated to the date of the claim. Now, as an aside, he's our client, so we wouldn't be giving him this advice, but as an aside and for information, his mother, who was the partner of the refugee at the time he became a refugee, should be eligible for a payment herself and should be granted an exemption from the newly arrived residence waiting period herself, as long as any other criteria are considered as well, because she is a family member of a refugee. Now, his older brother, depending on whether he is also under 22 years of age and in full-time education, may not be eligible because he may be over 22 years of age or older. He might not be in education, or there might not be some other reason that he would be eligible. But his mother and he should be able to get that payment, get a Centrelink payment because of the refugee exemption. So coming back to this slide again, when we're having a look, are you on that eligible visa? The non-migration issues, are there any issues there that might mean you can't get the payment? Is there that 10-year qualifying residence period? Have you been here long enough? Is there a newly arrived residence waiting period? Have you been here long enough? If you haven't been here long enough, do one of the exemptions apply? And if they do, then lodge an application. Remembering that if you become an Australian citizen before your waiting period, the newly arrived residence waiting period is complete, you don't need to finish the remainder of the waiting period. But if it is that qualifying residence period, it is irrelevant whether you become a citizen or not, you still need to sit out and wait for that 10-year qualifying residence waiting period. So it is a time for a pause again.
Okay, yeah, if anybody has any questions, please feel free to put them into the chat. Again, we cannot we can't give out legal advice, so they do have to be broad questions relating to the content, please. So there's a couple of questions here. If a client has fled a country on a refugee visa, would they only qualify for entitlements pending if the visa is permanent, or would temporary qualify them?
It entirely depends on what visa number they are on. I know there are some temporary humanitarian visas and there are some permanent humanitarian visas, you need to check every single number of the visa that they're on, because I wouldn't want to give a blanket rule that about anything. I'd be checking every single number to check what they're on. My understanding is that every single permanent humanitarian visa, there is an exemption to the newly arrived residents waiting period, and that you get access without that newly arrived residents waiting period to Centrelink payments. For temporary humanitarian visas, my understanding is that for at least some of those temporary visas, you get access to a limited number of Centrelink payments. So some temporary humanitarian visas will get you access to special benefit, might get you access to other supplementary payments. But as I said, you have to check every single visa number to see what the specific eligibility and grant options are for that visa number.
This is also in regards to temporary humanitarian visas. Somebody was wondering if you held one and it ceased and you are currently on a bridging visa for a different visa, permanent residency, would you still be eligible for the payment?
It's very specific to the visa that you are currently on. So you might have access to a social security payment because you're on one particular temporary visa. You're then moved on to, say, bridging visa A. And bridging visa A gives you no access to any Centrelink payment whatsoever. However, one of the other bridging visas, and I can't remember what letter it is, does give you access to some limited number of social security payments. So I can't even say bridging visas give you access or not, because each of the different bridging visa letters gives you a different access to Centrelink payments.
Okay. Regarding the Asha case study, will the payments be stopped once he turns 22?
No, once that newly arrived residents waiting period is waived, it is waived permanently. So it doesn't stop when he turns 22. It doesn't stop if he stops being in full-time education. So it might be that he's in a 12-month intensive English course, full-time intensive English course. That's full-time education. He's under 22. He gets access. That newly arrived residents waiting period is waived. Then he finishes that course and does something else. His access to Centrelink is that's it. He's got it. That waiting period is waived. It doesn't recommence.
Again, with the Asha case study, would the family receive a back payment if there was an error and they were eligible?
It entirely depends on what's happened. So if you lodge an application and that application is rejected, and you believe that you shouldn't have been rejected because you believe that you have an exemption from the newly arrived residents waiting period because you are a family member or dependent child of a refugee. If you lodge your appeal within 13 weeks of that rejection happening, and your appeal is successful, you appeal to an authorised review officer, the appeal is successful, the authorised review officer finds that you are a dependent child of a refugee, you should have been granted the payment. As long as you lodged your appeal within the time limit, which is 13 weeks from the date of the decision, you'll be back paid your payment to the date that you first submitted your application. If you don't lodge your appeal in time, then you don't get back paid to the date you lodged your application. You get back paid to the date you lodged your appeal. If you never submitted your application in the first place because you were told by someone that you don't bother lodging an application because you've got a waiting period and there's no point, You don't get back paid to the date you first talked to someone at Centrelink. You can only be back paid to the date you actually submitted your application.
Well, that's all the questions we have at the moment.
Do you know what? We're running really early because right now it's time for our break. Rules for accessing special benefit depending on your age. So, how do you actually get access to that special benefit when you're on a newly arrived residence waiting period? That waiting period for special benefit is 4 years, okay? So in order to get that waiting period waived, you need to show that you've had a substantial change in your circumstances, that that change was completely beyond your control, and that change happened after arriving in Australia. Now, in most cases, the change needs to have happened after being granted permanent residency. It can't have happened while you're on a temporary visa. And you also need to show that you're in financial hardship. When you're thinking about what a substantial change might be, it can include things like illness preventing you from working, or your sponsor or your partner being ill and preventing you from being able to work, your sponsor or partner losing a job, or sponsor or partner passing away. It can be where there's a breakdown of relationship where there is domestic violence. The mere breakdown of a relationship isn't necessarily going to be seen as a substantial change, but if there is domestic violence, it can be seen. It might be that the birth of a child or becoming responsible for a child with a medical condition can be a substantial change in circumstances. The mere birth of a child is not. Or it can be where a sponsor or partner becomes incarcerated or enters long-term facility. So this particular situation is where Lam had a minor heart condition 15 years before arriving in Australia. The condition was completely repaired in their home country, and they were considered to no longer have a heart issue of any sort. And before being granted their permanent residency, Lam had to undergo a medical assessment in her birth country, and the assessment was done by Australian doctors who found there were no medical conditions of note at all. 12 months after arriving in Australia, she was diagnosed with serious heart failure and was recommended to undergo a quadruple bypass and could no longer work. When she applied for special benefits, citing that heart condition as a significant change in circumstances and the heart condition leading to being unable to work, being the financial hardship, Centrelink said that there'd been no change in circumstances because it was a pre-existing heart condition. So Lam appealed to the tribunal, was able to show the medical assessment done prior to immigration, and the tribunal found that she did not have a pre-existing condition, that the heart condition and the resulting financial hardship was a significant change in circumstances, and that special benefit should be granted and the newly arrived residence waiting period should be waived. So when you're looking at family and domestic violence as a substantial change in circumstances, that change, that domestic violence needs to have occurred after arriving in Australia, and it needs to have usually needs to have occurred after being granted permanent residency, unless there's exceptional circumstances. And where family and domestic violence is the cause of the substantial change, that can be seen as an exceptional circumstance. And so the family and domestic violence can have occurred after arriving in Australia, but before being granted permanent residency. So for many things that needs to have occurred, that substantial change needs to have occurred after the grant of permanent residency, but that family and domestic violence is seen as an exceptional circumstance. And look, if you've got a situation where you've got a client with a substantial change in circumstances starts before permanent residency, have a look and see if you think it should also be considered an exceptional circumstance. But, you know, domestic and family violence is usually seen as one for the purpose of special benefit. So Mel contacted us while she was living in a homeless shelter. She was a teenager and she'd had to leave home due to domestic violence. She tried to claim a Centrelink payment, but had been rejected because she was not on an eligible visa. So we sent her away to the Immigration Advice and Rights Centre to seek advice and assistance on her immigration issues, and told her to come back to us when she got a permanent residency. She came back a few months later saying that she got a permanent residency, she'd applied for a payment and was rejected because of the newly arrived residents waiting period, and she couldn't return home. She had no idea what to do. She was still living in the refuge, in the homeless shelter. We helped Mel to get in touch with a Centrelink social worker. The social worker talked to her and understood what the situation was, and the social worker recommended that Mel be granted the special benefit because the violence started after arriving in Australia, but before she became a permanent resident. And that special benefit was backdated to the date that she first applied because she'd lodged her appeals in time. So one of the other exemptions is what's called the lone parent exemption. Now, if you became a lone parent, a single parent, after arriving in Australia and after becoming a permanent resident, then you can get an exemption from the newly arrived residents waiting period if you're trying to access parenting payment single, youth allowance, and the job seeker payment. So you do still have those other eligibility criteria for those payments. So you need to remember that those, all of the eligibility criteria that everyone needs to have for accessing those payments is still there, but you can have that newly arrived residents waiting period waived. Now, the issue here is that if you became a lone parent while on a temporary visa, if your permanent residency visa wasn't granted until after you became a single parent, then the exemption does not apply. So you may have become a single parent, days, weeks, months before being granted your permanent residency visa, and you will need to wait out the 4-year newly arrived residents waiting period, unless there was domestic violence involved in becoming a lone parent. Then you might be able to argue that there is a significant change in circumstances, a substantial change in circumstances that was beyond your control, and lodge an application for special benefit. So this is one particular situation where Zena arrived in Australia. She met her future partner, Mike. They moved in together. Things were going brilliantly, and then she gave birth to her daughter. And from that moment on, Mike became increasingly controlling and increasingly violent. On the day Zena got her permanent residency, Mike threatened to harm their daughter. Zena wanted to leave, but had no idea how she could could financially support herself. She eventually contacted us or heard about us and knew to reach us after she'd been a permanent resident for almost 18 months. Okay, so after we talked to her, we gave her advice. We talked to her about how there is absolutely no waiting period at all for Family Tax Benefit B and childcare subsidy. And she was eligible to lodge an application for those payments on the day that she became a permanent resident. That there was only a 1-year waiting period for Family Tax Benefit A. So 12 months after she became a permanent resident, she could lodge an application for Family Tax Benefit A. But there is a 4-year waiting period for parenting payment, and that nothing that she had happened at this stage and first contact gave her access to parenting payment before her waiting period had ended. However, if the relationship was to end, and if she was to leave the relationship, then she would have become a lone parent, a single parent, if her daughter went with her. Then she would have become a lone parent or a single parent after being granted permanent residency. And she would be able to lodge an application for parenting payment and ask that that waiting period be waived because she became a lone parent after the permanent residency was granted. Now, if it had been a slightly different situation and if she had left the relationship before the permanent residency was granted, then she could have lodged an application for special benefit because the relationship has broken down as a consequence of family and domestic violence. And because of that breakdown in a relationship, she is in severe financial hardship because she is no longer financially supported by her husband. And she should be eligible for special benefit without having to sit out that waiting period. So heading back to this slide, this particular slide, and we're having a look at that process of talking to your clients and going through the stages to work out what they may be eligible for and what Centrelink options they may have. So we're looking first at first question, what's your visa number? Can we look it up? Can we see if you're on a visa that gives you access to any Centrelink payment? Okay. If they are on an eligible visa, if they do get access to Centrelink payments, then look, what's your personal circumstances? Are you eligible for the payment you've chosen? Are you looking at carer payment? Are you caring for someone in the appropriate way? Are you looking at one of the family assistance payments? Are you caring for a child who is a family tax benefit child? Are you looking at one of the income support payments? Are you looking at the job seeker payment? Are you prepared to look for work? Are you looking at youth allowance? Are you of the appropriate age? Are you in education? Are you looking for work? You're looking at those questions of what are those eligibility criteria for those particular payments. If that's clear and if that's fine, then we're looking at, is there a qualifying residence period? Is there that 10-year waiting period for that payment that you're looking for? And if they've been here long enough. If there's no qualifying residence waiting period, is there a newly arrived residence waiting period? Is there that 4-year, 2-year or 1-year newly arrived residence waiting period for the payment that you're looking at? And when was your permanent residency granted? Or when did you arrive in Australia? How long have you been physically located in Australia? Have you been here long enough? Have you been here for the full years, 2 years, or 1 year, or not? And at any point, at this point, if it is a yes, then you lodge your application. You put in an application, you test your eligibility. If you haven't been here long enough, if your client's not been here long enough, then you start looking at those exemptions. Did you arrive in Australia on a humanitarian visa? Are you a refugee? Are you a family member of a refugee that fits those very specific definitions of who can be considered a family member? Has there been a significant change in your circumstances that is beyond your control? Have you become a lone parent since you've been granted your permanent residency? Is there any option to have that newly arrived residence waiting period waived or reduced? And can you lodge an application for a payment and be granted before that waiting period ends? And if the answer is yes at any point, pop in an application, lodge your application, test your eligibility. If you're walking into a Centrelink office and the person behind the counter doesn't completely understand your situation and they say, don't apply, don't bother applying, you've got a waiting period, don't bother. Look, pop in an application anyway, test your eligibility. If they say no, you've got the right to appeal. You can also seek legal advice to see if maybe there's been a misunderstanding along the way. There might have been an error somewhere, okay? If there's not been a significant change in circumstances, if none of those exemptions appear to exist, seek legal advice. Okay, so if you go to our peak body, Economic Justice Australia's website, there's a page on there that gives you links to all of the different community legal centres throughout Australia that do work in the social security area that assist people who have got issues with their payments from Centrelink. So we have funding to assist people in New South Wales. So we'll help people in New South Wales, and there's different community legal centres around Australia that can help you if you're not located in New South Wales. All right, questions?
Okay, so sorry, multitasking here. Does the lone parent provision apply to single parents with shared care or only solo parents who have 100% care?
My understanding, but I would want to test this and check it, is that you need to have just become a single parent. Even if you have shared care, that's not considered and it's not a factor. If you have shared care, it might impact how much family tax benefit you receive, because family tax benefit can be paid based on the percentage of care that you have of your child. But otherwise, if you became a single parent, if you became a lone parent, you get access to those 3 payments, as long as all the other circumstances are there.
If a client receives the special benefit and gets a victim of crime payout, does that affect the special benefit?
So that liquid asset test, that $5,000 liquid asset test, can be applied very strictly. So if that is a situation that you or your client finds yourself in, then have a chat to Centrelink about it, and have a chat to them and see what they have, what information they might be able to give you, and if there is any options for you. But that's a chat to Centrelink matter. If your client is rejected for a payment, or if their payment is cancelled because they received a victims of crime payment that pushed them over that $5,000 limit, they have a right to appeal that decision to cancel their payment. They need to lodge the appeal within 13 weeks, and they can come to us, or they can come to another community legal centre that specialises in social security law to get advice on whether that was the correct decision or not. I can't give advice now.
Okay. I'll just read out how it's written. Just wanting to clarify a point made earlier regarding some bridging visa holders potentially being eligible to apply for Centrelink, even though they're not permanent residents. Is this by chance in reference to the status resolution support services payments, which is specifically for people seeking asylum, or are there some other exceptional payment BV holders are also entitled to apply for? Sorry.
So the SRSS payment, that status resolution support services payment, is not a Centrelink payment. It's not a social security payment. I will be briefly mentioning it later. With those bridging visas, it is really important to look up each of them on their own. Unfortunately, once I'm in the middle of this slide set, I can't go back and look. Yeah, I can't look at specifics. But that link that it was there on the slides earlier, I imagine it would have been put into the chat, or if it's not, I'm sure it can be. We'll take you to a page called the Social Security Guide, and that is the page that we use every single time visas come into question. We go directly to that page, we look up the visa number, and we check every time. So you can just pop on now or any time and have a look at those bridging visas.
Okay. So Thea said I should run this by you. It might be a little out of our scope, but could you explain about the assessment for the Special Disability Trust for Centrelink, or is that?
So
not.
unfortunately, look, special disability trusts are not a migration issue. Unfortunately, that's more probably more appropriate for maybe our disability support pension or our carers sessions. But if you have someone who is wanting to set up a disability trust or is struggling with access to a Centrelink payment because of a disability trust, then it might be that you need to contact your local community legal centre to see if you can get some advice, or contact Centrelink and ask them about setting up a disability trust and what it entails and how it will impact your access to a payment.
Sorry, that one doesn't, I'm not sure what the question means. Sorry, Thea. Unprotected special category visas ineligible for Centrelink benefits?
So that's a New Zealand question, so we're going to be covering that in a little bit.
Okay. Oh, I think I know what this question means. So if somebody was experiencing domestic violence in the country they were living in, and they came to Australia, would that entitle them to payments in any way?
No.
Okay.
So if you know, it's what's happened after your arrival in Australia. So it's, you know, what visa are you on? And what's happened after arriving in Australia. What happened before you came to Australia doesn't count as a significant change in circumstances to get access to the special benefit.
If a client has fled a country on a refugee visa, would they only qualify for entitlements pending if the visa is permanent or temporary?
It entirely depends on what specific visa you are on, because some temporary visas give you access to a limited number of Centrelink payments. Most temporary visas get you access to no payments, but some do. So it completely depends on what specific visa number you are on. So follow the link, have a look.
A lone parent who has not yet gained permanent residency, can they apply for either special benefit or parenting payment?
No. So if you are a lone parent on a temporary visa, unless you're on one of those temporary visas that gets you limited access to some payments, you don't get access to a Centrelink payment. And if you became a lone parent before being granted permanent residency, then you don't get access to the lone parent exemption. That will mean that you no longer, you don't have to wait out the waiting period for parenting payment, job seeker or youth allowance. It's only if you became a lone parent after getting your permanent residency that you can get access to parenting payment, youth allowance and job seeker. Now, if you became a lone parent due to a breakdown of a relationship as a consequence of domestic violence, and because of that domestic violence and breakdown of relationship, you're in financial hardship, then that situation can have occurred before getting your permanent residency visa, and that can be seen as a significant change in circumstance that might get you access to special benefit before your 4-year waiting period is completed.
I believe that is, oh, there's another one has popped up. A lone parent on a student visa, but the other parent is an Australian citizen. Would they be eligible for anything?
Now, I'm wondering if maybe my next set of slides could be helpful to you. So let's have a look at those slides because they might be of use.
Okay, we'll keep going. And we were talking in the break, and we had decided that if we do finish a little bit early because we were running early, that maybe we'll be able to answer some questions at the end as well. So
we'll see how we go. We are, yeah. All right. So this, I'm hopeful, might be helpful to that last person, the last question. There's such a thing as special benefit children. So if you have an adult who's lodging an application for a payment and they are not eligible due to their residency, it's not if they're not eligible due to something else, you know, but if it's purely because of their residency, because they are not on a visa that means that they are eligible to apply for a payment, then it is possible that their children may be eligible for a payment instead. If the children are Australian citizens or permanent residents, and if the parent caring for the child is on a temporary visa that has absolutely no access to any Centrelink payment at all of any sort, then the child should lodge an application for a payment. And that child can be 1 week old. That child there is no specific age restriction on how old that child can be to lodge an application for special benefit. That payment, that special benefit payment, is paid to the parent until the child is 18 years old, or until the child is considered independent for youth allowance and can get a payment, one of the normal standard Centrelink payments. Because remember, special benefit is only paid if there is absolutely no other payment whatsoever someone may be eligible for. So for the moment that child becomes eligible to apply for youth allowance, they can no longer get special benefit. Okay. Now, what that child's eligibility might be changes depending on their age, depending on their living situation, depending on whether they might be enrolled in school or not. And the moment the parent that cares for the child becomes a permanent resident, then that child's eligibility for special benefits ceases and their payment will be cancelled. Okay, so the thing to remember though is that if you have a client whose child might be eligible, has applied for the payment and is getting it, that payment stops because your client becomes a permanent resident, then losing the child's special benefit, losing that special benefit payment can be seen as a substantial change in circumstances beyond their control that caused financial hardship, and can be seen as an exemption for the parent for the newly arrived residents waiting period for special benefit. So they can lodge an application at that point for special benefit in their own name.
Welfare Rights Centre, this is Julius.
Hi, I'm ringing because I've got a bit of a problem at the moment. I've just had to leave my house with my 4-month-old daughter and I don't have any money. I can't afford food. I can't afford rent.
I'm so sorry to hear that. It sounds like you're in a really difficult situation. When did you leave your home?
It was about a month ago. My ex-partner was violent and abusive. I couldn't stand it anymore.
Okay. And how have you been supporting yourself since then?
Just of charities and the refuge I'm staying in at the moment.
Have you tried applying for any Centrelink payments?
Yes, I did. I applied for parenting payment, family tax benefit, but I was knocked back.
Okay. And when was it rejected?
I think it was sometime last week. I can't remember what day.
Did Centrelink say why they rejected it?
They said it was because I'm not an Australian resident. I applied for permanent residency, but I haven't got it yet.
All right. And do you know the name of the visa that you applied for?
Yes, I applied for the 820 partner visa a few months ago, but I haven't heard anything back yet.
All right. And what visa are you on at the moment?
I'm on a bridging visa A.
Okay. So you mentioned earlier that you fled your home with your daughter. Is she an Australian citizen?
Yes, she is, because her dad is a citizen.
All right. I think it'd be useful to book you in to speak to one of our solicitors. There's no charge. We're a free service. Would you like me to go ahead and do that?
Yes, please. Do you think you can help me?
I'll need the solicitor to look at everything properly. I'm not sure if we can get you one payment, but there's at least a chance that your daughter might be eligible for a payment. This matter is obviously urgent, so I can book you an appointment next Tuesday. Can I double check that you're able to stay in refuge till then?
So thinking back to that story that we just heard, the person on the phone had recently separated from their partner. There was family and domestic violence. There's a 4-month-old child born since arriving in Australia. The person on the phone had no source of income, so they were in significant financial hardship, and the child is an Australian citizen. So when an application was lodged on behalf of the child, special benefit was granted to the child. But the person on the phone, the client, needed to be advised that once her visa was granted, if she was granted a permanent residency visa, then the child's special benefit was going to be cancelled, and the mother was likely to be granted special benefit due to a significant change in circumstance. But then there's 2 reasons why she might be granted, and there's 2 reasons for that change in circumstances. Not only was it the loss of the child's special benefit, but it was also the breakdown of the relationship because of family and domestic violence. So we've now reached the end of that original slide that we went through, and hopefully it's clearer now, and hopefully it's helpful. So we've looked at the visa, those waiting periods, the exemptions and the exceptions to the waiting periods, that change in circumstances. And then if we head up the top there, after that very first question, are you on an eligible visa? No. Do you have children who are citizens or permanent residents? Yes, then the children might be able to apply. So, questions?
Okay, so there are a few questions. This one, okay. If the parents' relationship is not legally recognized and the father is an Australian citizen but hasn't accepted paternity, would the child still be eligible for any payment?
So I don't know how much of that may be related to an immigration question. If that question relates to whether the child would have access to a permanent residency visa or citizenship based on the father's citizenship, I don't know. I'm not an immigration lawyer, and that's not something I'd be able to say. Otherwise, if it's purely a Social Security and Centrelink question, it's right back to basics. You know, what visa is the child on? Is the child a permanent resident? Is the child a citizen? And if they are, then as long as the parent who has care of the child has absolutely no access whatsoever to any Centrelink payment because they are not residentially qualified, then the child may have access to special benefit.
Okay. When the child applies for special benefit, does the adult have to provide ID documents as well as the child to access the payments? And if the child is a newborn and has no ID documents, how would they do that?
The question about the parent and ID documents, you know, I can make assumptions on what the answer might be, but because I actually don't specifically know, I wouldn't want to answer without looking it up. And then if the child has been born in Australia, I imagine they've got access to a birth certificate. But once again, what ID documents an individual may have access to depending on their age isn't my area of expertise, so I cannot answer.
Okay. Oh, there's another question. If a client is unlawful at the time of leaving domestic violence, a domestic violence situation, can a child still apply for special benefit? Unlawful.
I'm really sorry. I don't know what the definition of unlawful
Yeah,
is. I can't answer that question. Look, with a lot of these questions, you know, it might be lodge an application, test your eligibility. If your application is rejected, get some legal advice, appeal the rejection.
Okay. If there is a New Zealand citizen and they are on a bridging visa for permanent residency, and they were a victim of domestic violence, is there potentially any Centrelink payments that they could get due to the hardship?
So for New Zealand citizens on the 444 visa, I will be talking about those in a moment. For bridging visas, it's once again, have a look at that link, look up the specific bridging visa and see what they might have access to.
Okay. I think that's it for the moment. If anybody thinks that I've missed your question, please put it back in. Yeah, and also please keep them broad. Again, we can't give out legal advice. Yeah, so just broad questions relating to the content, please.
Okay. So other issues that people who are migrants or newly arrived residents might be experiencing when trying to access a social security payment. So there are a number of international agreements that Australia has with other countries. There's a partial list there. There is a link at the bottom of that slide that takes you to a list of all of them. Every international agreement is different. So each agreement has different needs, different access, different requirements. Often they only cover the age pension or the disability support pension, and they can include an ability to make an application for a payment from Australia in another country, or in Australia from another, the payment from another country. There can be issues with being able to receive a payment when you're on an international agreement if you're in a country other than one of the two countries involved in the agreement for more than 28 days. So say if you're in, you're receiving a payment through the agreement with, Canada. I'm just looking at, I don't know the specifics of this particular, international agreement, but say you're receiving a payment, because of the international agreement with Canada, and you go to Indonesia for more than 28 days, then your payment may be cancelled. Okay, so just be aware of that style of thing. With these international agreements, it may be possible that you can access a Centrelink payment through an international agreement if you're on a qualifying residence waiting period. So if you're finding that someone has that 10-year waiting period, maybe have a chat to them about whether there may be an international agreement that could give them access to a payment. Okay, so New Zealand citizens. New Zealand citizens traditionally enter Australia on a special category visa. It's granted automatically on entry. There is no need to apply for this particular visa. If you arrived before the 26th of February 2001, then there are different rules for you. Okay. What we're talking about today is only for people who arrived in Australia after the 26th of February 2001. Now, these people are eligible to live in Australia permanently. There is no restrictions on their ability to work here. They have to pay Australian taxes and they're eligible for Medicare while they're here. However, they have absolutely no eligibility for Centrelink payments at all, with some exceptions. You'll find that there's almost always exceptions to everything. So as a New Zealand citizen, you get access to childcare subsidy, family tax benefit, Commonwealth Seniors Health Card, foster child health card, low income healthcare card. Okay. You get you can claim the newborn upfront payment and other things as well. So it's worth having a look and seeing what might be available to you as supplements and those payments that might be available if you're caring for children. So other than those particular payments, what support might possibly be available to you as a New Zealand citizen? you might be eligible for the age pension as long as you've had 10-year residence in Australia and New Zealand combined. So there's still that 10-year qualifying residence period for age pension. However, for New Zealand citizens, it can be, you can do that residence in both Australia and New Zealand combined. Time spent in New Zealand has to have been of working age, but time spent in Australia can be at any age. You might get access to the disability support pension through the New Zealand International Agreement, but there is a lot harsher eligibility requirements than the Australian disability support pension. You need to be considered severely disabled, and you must have become disabled either in Australia or New Zealand. If the disability occurred before becoming a permanent resident of either Australia or New Zealand, you won't be able to access it. And if you're caring for someone who is receiving the disability support pension, you might be able to get access to carer payment. Now, I'm hoping that this particular bit here might answer a question that came up earlier in the session. If you are a New Zealand citizen, if you have lived in Australia for 10 years cumulatively, you can get access to job seeker payment or youth allowance in limited circumstances. You can only receive it for 6 months in total. If you lose eligibility during the 6 months, say you get a job or something, then you cannot get the remainder of your 6 months at a later date, and you can only ever receive this 6 months of payment once in your lifetime. All right. So for other people who might have eligibility for a foreign pension or might have overseas income and assets, Centrelink can require that you lodge an application for a foreign pension before they assess your eligibility for a Centrelink payment. And those foreign pensions are considered income for Social Security purposes. If you have a client who has assets outside of Australia, whether it's property or bank accounts or any sort of debt, any sort of asset outside of Australia, they need to be declared to Centrelink because they will be assessed under the asset test. And if Centrelink discover that you had assets after you've been receiving payments, then you are at risk of having a debt raised if you were received more money than you were entitled to. If there is a reason you can't sell or sell an asset, get rid of an asset or derive income from it, then you might be able to lodge an application for asset hardship. So there is other financial assistance that may be available. It's not necessarily easy to get access to this other financial assistance, but it's there. One has already been mentioned very briefly in a question, and that's the SRSS payment, and the other one is what's called the Act of Grace. These are only available for people who don't have access to any other Social Security payments. So that Status Resolution Support Services payment, or SRSS payment, is a payment aimed at refugees and asylum seekers. If they're considered to be living in Australia unlawfully, they hold a bridging visa E, they have applied for a temporary protection visa or a safe haven enterprise visa, and they're struggling to resolve their immigration status, or they've just recently been released from immigration detention, then they can make an application for this Status Resolution Support Service payment. In New South Wales, those applications are made through two organisations, Life Without Barriers and Settlement Services International. If you want to know what organisations can assist with this particular payment in your state, the Department of Home Affairs has that information on their website. It's not a payment that we're able to give advice and assistance with because it's not a Social Security payment. And so we can't assist with that particular one. The other payment that may possibly be available is what's called an Act of Grace payment. It's a discretionary payment. It's administered through the Department of Finance. It's not a Centrelink payment. It is not administered through the Department of Social Security. It is a last resort payment. It's a remedy of last resort. It might be a single one-off payment, or you might be granted an act of grace that actually is the equivalent of a standard Centrelink payment that you receive fortnightly. You need to have exhausted every option for getting financial support from somewhere else before they will even consider an application for act of grace. So you need to have exhausted any possibility of getting payments from a country of origin, and it will only be paid when special circumstances exist. Okay. They can also review your eligibility periodically. So your payment, that grant of an act of grace may not be permanent, it might not be indefinite, and you might need to pursue changing your visa status. You might need to apply for a permanent residency in order to try and get ongoing Centrelink support. Otherwise, that act of grace payment may not be continued. So we had a particular client who was successful in an act of grace application and started receiving fortnightly payments, believed would never be eligible for a permanent residency visa, so never bothered applying, never tried. And after a period of time, the Department of Finance went, you haven't tried to change your status. You haven't tried to get access to financial support through another means. They reviewed their act of grace payment and cancelled it. And even though more applications for act of grace were lodged, it was never granted again because they'd never tried to change their status. So, final bits and pieces, and we will be finishing early, so I am happy to answer questions for people for up until 4 o'clock for as many questions as you happen to have. So there is a payment finder tool on the Centrelink website. Use it, have a look through it, see if you'll be able to work out what sort of payment you might be able to get access to. The link is there. However, it is an indication only. If you believe from the information you have or the information you've received here that your client may possibly be eligible for a payment, even though that payment finder tool says no, lodge an application. Test your eligibility. If your application is rejected, then lodge an appeal. Okay. And with appeals, the thing to remember is that any Centrelink decision can be appealed. There are time limits involved. So if you receive a decision that rejects an application for a payment, then you have 13 weeks to appeal that decision to the internal review of an authorised review officer. If the authorised review officer confirms that rejection, then you have 13 weeks to appeal to the Administrative Review Tribunal first review. If the Administrative Review Tribunal affirms that rejection, then you have 28 days to appeal to the Administrative Review Tribunal second review. Okay. One of the things that we'll say is that the appealing debts, there is absolutely no time limit. And I say this in every single session that I do, whether I talk about debts or not. My advice is don't appeal a debt without getting advice, even though there's no time limit, you can appeal them, but debts can increase when you lodge an appeal. So get advice first. Okay. So key points to take away. Get your clients to test their eligibility for a payment, even if the person on the end of the phone at Centrelink, or even if the person on the other side of the counter in the Centrelink office says that they're not eligible because of a waiting period, test your eligibility. As you've hopefully seen, it's an incredibly complex system. Okay, so put in an application and test. And if your client's been rejected for a payment, they can appeal that rejection. They've got 13 weeks to appeal most rejected payment applications to an authorised review officer. You can come to us. You can come to one of the other organisations that give Centrelink advice for advice. All right. Questions?
I don't think there are any.
That's okay. We'll
Oh,
just keep
sorry,
going.
apparently there is one. 1 second. Oh, can you receive social security payments from both New Zealand and Australia? If so, what is the effect of receiving either payment on the other?
I don't know what impact receiving Australian social security payment would have on your New Zealand payment. Unfortunately, that's not one of my areas of expertise. However, any income that you receive from the New Zealand government would be considered income for social security purposes and would form part of an income test.
And that would be it.
That's okay. We'll keep going. So if you're supporting a client with Centrelink and they have issues relating to speaking a language other than English, there is access to information on the Services Australia website in other languages. Just have a look for those symbols. They have printed audio and video resources in a really wide variety of language. They also provide a free interpreter and a translation service. So they have a specific telephone number that's the multilingual phone services phone number 131202. Your clients can call that number. People on the end of the line will be able to assist in their language of choice. They will be able to assist with giving information, assist with lodging applications. It's all sorts of help that they can receive from that number. If you are a community worker, and it's very important, this is for community workers only and not for applicants, but community workers can contact multicultural service officers in their state. For New South Wales and ACT, the email for the multicultural service officers is there on that slide. It is only for community workers. It is not for clients and applicants. For any other state or territories, please contact Services Australia and ask for the email address for your local multicultural service officers. If you're helping your client access Centrelink, then you can also be authorised, or your organisation can be authorised to inquire on behalf of your client. There is a particular form that your client can complete. The link is there online. This isn't something that we as lawyers are able to do, but your community workers may be able to do it on behalf of their clients. And Centrelink also offer digital coaching. So if you have a client who struggles with digital literacy, then Services Australia offer digital coaching to support people to access their services online.
I'm sorry, that would be me. Second. Okay, so we have a new 2024 Welfare Rights Centre poster available that you can download via our website for easy visual referral to our services. There's a little snippet of that on the screen. Our community worker training schedule is accessible on our website, along with recordings of some of our previous sessions. More recordings will be available for viewing soon. You can sign up to our newsletter through our website to receive notifications for when they're available. We have online resources such as our fact sheets available on our website as well. These deal with some common Centrelink issues. We'll be adding further to these resources throughout 2025. If you have a problem with Centrelink in New South Wales and you wish to speak to someone at Welfare Rights Centre, our client intake line is open every Monday and Wednesday from 9:30 a.m. till 12:30 p.m. Or you can contact us online through our website or via email. Please follow us on Facebook, Instagram, and LinkedIn for regular updates and educational information. And lastly, we would really appreciate it if you could take 5 minutes to please complete our evaluation survey. That should have arrived in your inbox, well, about now, actually. Your feedback helps us to improve and also to secure funding so that we can continue providing free webinars like the one you attended today. We hope that you enjoyed the session and we look forward to seeing you at future events. Thanks, Donna.
Now, we have finished early, so if anyone does have any last questions, I am happy to answer them.
Okay.
I imagine there may not be any, and that is
No,
completely fine.
there are a few.
Okay.
I think people save some till the end. Okay. If a refugee brings money with them from overseas, does this limit their eligibility for job seeker?
So almost all Centrelink payments have an income and an asset test, and any income that the person receives or any assets that they have, and money sitting in a bank account is considered an asset, will be looked at as a part of that income and asset test.
There is a question. If somebody is on a Centrelink payment and they want to travel overseas, what are some things to consider is time period wise?
It completely depends on what payment you're on and why you are traveling overseas. It's worth having a chat to someone at Centrelink and asking them, you know, about how will my travel will impact my Centrelink payment. Most payments you cannot receive for longer than 28 days when you're out of Australia, and that 28 days accumulates over 12 months. But as I said, every payment can be different and the reason you are leaving can be different.
Do you happen to know with the age pension payment?
I'm not going to give any specific advice.
Yeah, so they would have to contact Centrelink.
There is a I'm not sitting at my desk. I don't have the telephone number sitting on my board next to me. There is a telephone number that is specifically for people on the age pension. I'd be giving that telephone number a call and saying, this is my situation. Can I please get some information and advice?
If a New Zealand citizen becomes a lone parent due to family and domestic violence, would they be eligible for a special payment?
It will completely depend on what visa number they are on. If they are on the 444 visa, then as I've said, the payments that they get access to are the ones that I've gone through. They get access to some payments that are specifically recognising care you may provide a child, and they, depending on whether they've been in Australia for 10 years or more, they may get access to the job seeker payment for 6 months. It might be that it's worth having a chat to an immigration lawyer to see if the 444 visa is the best visa for you, or whether you might be able to apply for a different residency status.
And I believe that might be the end. Okay. Yes, it is.
Well, thanks for coming, everyone, and thanks for asking all the questions. And I hope that it was useful for you, and see you next time.